behalf of Merricks and Mastercard Incorporated and others.
Yes,
My Lord, as your Lordship's aware, the function of the domicile date is to determine whether a person who falls within a class definition is domiciled in the United Kingdom and is therefore automatically included within the proceedings unless they opt out, or whether the person will only be included if they opt in. It has a purely jurisdictional function to avoid extraterritorial reach. Mastercard submits on this appeal that setting the domicile date 5 years earlier than the date on which the court decided to assume jurisdiction over the class of individuals was a remarkable order. And my Lord, to put that submission in context, under the collective proceedings regime, there have now been 8 orders granting CPOs, including in this case. In every other case, the domicile date has been set as the date of the decision to grant a CPO or the CPO itself, the 2 dates often being the same.
Is there any other case in which the CAT's refused to grant a CRO and then there's been an appeal to the Supreme Court and it's taken 5 years?
No, my Lord, but if the factor is just simply the time of the court proceedings, then I'll come on to address that, but we would say that is a factor that can't determine territoriality and jurisdiction.
If the CAT had got it right first time round, and the Court of Appeal got it wrong, and then the Supreme Court restored the CAT, would that alter your analysis?
No, my Lord.
So even though the domicile date was fixed at the date of the CPO first time round, Court of Appeal got it wrong, Supreme Court restores CAT.
Well, my Lord, it depends whether the CAT had at that stage fixed the CPO date. I should take that back.
Okay, assume it has, and fixed domicile date. Still got 5 years today.
Well, my Lord, at that point the date would have been fixed, and so yes, I accept that.
But still 5 years delay.
But there's still 5 years delay. But, my Lord, the essence of my submission on this appeal is using the domicile date to correct drafting issues, limitation issues, and court delay is an ulterior purpose that falls outside the statutory function. And my Lord, even though your Lordships may be, and I'll take this head on, may be sympathetic to the concept of the 5-year delay, there are 2 points to be made here. One, it wouldn't have made a difference had the claim form been drafted differently. So it's not right to put this down to court process or the delay from that for that reason. It is down to the deliberate and intentional drafting of the claim form. And secondly, this claim, when it was issued 5 days before the limitation period expired. That was also a choice. And limitation reasons often give rise to results on the merits that may be considered unattractive, but we don't circumvent the Limitation Act. We have those rules for a reason. Using a domicile date to overcome limitation issues, which is what's really happened in this case, we would say would set a very dangerous precedent, even if you're sympathetic to the 5-year delay.
But limitations stopped running when the claim form was issued, didn't it? Because that's when jurisdiction is found.
Indeed.
So what a CRO does is to continue proceedings which have already been commenced, in respect of which the court's already got
That's right, with the class as defined on the claim form, yes.
So that the suggestion that this is all to do with, as it were, the date on which jurisdiction is founded and putting the date on which jurisdiction is founded earlier than it should have been is actually a misconception, because jurisdiction is founded by the issue of the claim form.
Well, my Lord, the date on which the court takes jurisdiction over the class, we say is the relevant factor, and the domicile date is the date of the opt-in, opt-out point. And that's why I would put jurisdiction on the domicile date in these proceedings.
The statement
not.
of proceedings are continued, I think, is what it says, isn't it? Anyway, that is in a sense where the battle lines are drawn.
Indeed.
This is a very short point.
Indeed. I'm going to take it a little bit more slowly, my Lord, on the basis that I want to just show you.
I'm not suggesting you should take it more quickly this time.
It's always daunting when the court says it's a very short point and you have pages of
It can be a
submissions.
complex short.
My lord, you've obviously got the two grounds of the appeal in
Yeah.
mind. First is the exercise of the statutory discretion. We say it was exercised for an ulterior purpose for the reasons I've outlined briefly. And the second is that we say the approach to and the construction of the claim form was in any event wrong, and therefore, insofar as the tribunal took that point into its consideration and exercise of discretion, it took into account an irrelevant consideration. Now, Mo, can I just turn to the structure of my submissions, and I will move along quickly if the court indicates it. What I'd like to do, though, is take a few minutes to explain the background to the CAT's order, because it does take a little bit of picking through to see exactly what happened. I'll then briefly look at the CAT's judgment, which I'm sure your Lordship is familiar with, and then address you on the legal principles. I don't think there's much between us on those. And finally, briefly on grounds 1 and 2.
Yeah, we need what, core bundle?
You need the core bundle and the supplemental bundle, please. And if your Lordship could have open to start with the chronology, which is in tab 4 of the core bundle. And I'm also going to, because things are set out in different places, I'm afraid I'm going to have to take you through the two bundles. So the starting point is that the CPO application was made in September 2016 alongside the issue of the claim form, and the limitation period expired 5 days after that. If your Lordship then goes to the CAT's judgment in the following tab, at page 36 of the bundle, paragraph 6, your Lordship will see there the extract from the claim form defining the class. And what you'll see is, as I'm sure you've already looked at, the class is defined as the individuals between the 22nd of May 92 and 21 June 2008, falling into the relevant categories. The significant point is in the second sentence, which starts all individuals who are living in the United Kingdom as at the domicile date. So that's the crucial issue that arises, use the use of those words, to be determined by the tribunal in the CPO and who meet this definition. And if you read on it, it then goes on to say that they're in the class unless they choose to opt out. And then all those who are living outside the United Kingdom at the domicile date but meet the definition will be able to opt in. So the opt-out, opt-in decision is tied to the domicile date. You then go on to 23D of the claim form, which says in terms that the representative is aware that the class definition excludes some individuals who might have good claims, in particular the estates of individuals who meet the proposed class definition but who passed away before the domicile date. So 4 points on that, my lord. First, the claim form did not define the class as at the date of issue, which it could have done, but rather as at the domicile date. Second, the claim form recognised that the function of the domicile date is to determine who has to opt in and who has to opt out. The third point is that the claim form, as you've seen, expressly excluded claims on behalf of individuals who had passed away before the domicile date, and such individuals were not original parties to the claim. And on that point, can I just show you what was recorded in the tribunal's remittal judgment at paragraph 36, and that is in the supplemental bundle at tab 8. At page 81 of that bundle. And the cat there refers to a
Sorry,
no-
which one?
it's paragraph 36, tab 8, my lord,
Tab 8.
and page 81. And the cat records here that as at the time of the claim form, there was a notice about the proceedings that was published on the dedicated claim website. And if your lordship could read the extract. So what you will see is it's the Collective Proceedings Order application asks the tribunal to allow the proposed claim to proceed on an opt-out basis on behalf of all of individuals who are living in the UK, and these are the words I emphasise, at the time the claim is allowed to proceed. And that was published at the same time as the claim form. And I said to your lordship there were 4 points. The fourth point is the limitation point I've already made, that it was appreciated that this claim form was issued up against the limitation date. The next relevant document, my lord, which was also served with the claim form, and that's plainly significant, was the proposed timetable for litigation. And that is also in the supplemental bundle at tab 3. And the relevant point is at page 56 of the bundle, so one page over. And here you see on the box February-March 2017 on the left-hand side, expected domicile date. So that is when the claim was issued, it was suggested that the domicile date would be February-March 2017, not the date of the claim form, and there is nothing within the claim form we would suggest and these simultaneous documents to suggest that there wouldn't be a delay, therefore. And in particular, when you have that in mind and read paragraph 23D, it is accepted, therefore, that the class definition excludes some individuals who might have good claims, including those who passed away before the domicile date.
We don't see in this timetable any provision for appeals to the Supreme Court.
No. But what we don't see, though, is the suggestion that as at the time of the claim form, it was expected that all of those who were alive should be included. On the contrary, it is recognised that there might be a delay of at least 6 months plus, and that those people with good claims would not fall within the class. Now, my lord, this continued, so in its skeleton for the original CPO hearing in 2017, the proposed class representative suggested, and this is at supplemental bundle next tab, tab 4, they suggested again that the date on which the CPO is granted should be used as the domicile date. And can you see that at paragraph 41 of the document? So, and rightly, it was recognised by the proposed class representative as this is the point at which there is an actual claim that is proceeding before the tribunal in which the class members are included. Your lordship's then aware that plainly, the CAT heard the application in January 2017, dismissed it. It then went to the Court of Appeal and the Supreme Court. And the remitted application was heard by the CAT in March 2021. Now, at that hearing again, it is instructive to see the exchange between the proposed Class Representatives Council and the chairman. And it's the chairman's comments that are particularly instructive. So if one can go back to the supplemental bundle, please, to tab 6. So this is the March 2021 hearing. And what you see here, what was being argued, as I will show you in a moment in the judgment, is that the class definition on its face included deceased persons, and that submission was rejected. Now, and that's what's meant by the the reference in line 3 and 4 of the legal meaning of domicile date, and I'll show you exactly that. But what's instructive is you see Mr. Justice Roth. I know there's an argument, this is line 6, I know there's an argument about domicile date, but the domicile date is not going to be before the CPO is made. It's going to be, and you're not suggesting the domicile date is going to be in 1992, are you? No. And you see at 11, the judge says, no, it's going to be sometime in 2021. And leading counsel says, yes, sir. So that's still the position post all the remission back to, and the judgment to the Supreme Court. And again, that's reflected in the proposed timetable for litigation produced for the purposes of the remitted CPO hearing. And you see that at tab 5 of the bundle, supplemental bundle. At page 59. And you see 3 columns down, 3 boxes down, April, May 2021, expected domicile date. So this is what Mr. Merrick's own team expected, and this is what they were proceeding on the basis of. And the CAT then grants the application in August 2021. And if one looks at the judgment about that, that's at tab 8 of the supplemental bundle. This is the remittal judgment. And I'm going to show you this in more detail in a moment, but if you could just look at paragraph 57 at the moment, please, which is at page 87 of the bundle. And I'll let your lordship read that, please. It's the recording of the submission I just showed you in the judgment.
Yeah.
So, my lord, that's the background. Now, it goes a little bit more because we're going to see here the limitation issue finally come to the fore at this point in 2021 and 2022. So, the starting point was that it was at this hearing, the remittal hearing in 2021, that the proposed class representative first sought to row back from the pleaded case of excluding people who were no longer alive at the domicile date. Now, at this point in 2021, there was no suggestion, as you've seen, that the domicile date would be earlier than 2021. What was said was the class definition could be read differently. And you can see this in this judgment. If you pick it up at paragraph 33, which is at page 79. So it starts under the heading, the deceased persons issue. And this is the judgment in August 2021, just to put this in the time frame. So this passage starts with the description of the claim form which your lordship has seen. Over the page, on page 81, it then refers to the expert report about the size of class. And at paragraph 36, the CAT records that we therefore consider it to be clear to anyone reading the CPO claim form and application that Mr. Merricks intended to exclude people who were no longer alive. And you see the passage cited. And then we see at paragraph 39, the summary of the submission being made, that Mr. Merricks made clear he wants to include deceased persons within the class. And Miss Wakefield sought to argue this on the basis of the class definition in the existing claim form. Now, if your lordship just turns to paragraph 59, this is what appears to have been the submission.
Paragraph
59 on page 88. So the submission appears to be that you could interpret domicile as in a different way to perhaps the way one might ordinarily read it, and that a person's domicile survives their death. That was, I think, the argument, and that's what was meant by the legal meaning of domicile that we saw. So no suggestion the domicile date is going to move. It's the meaning of domicile in the claim form. If we then go back to paragraph 41, and that's at page 82, you see that the court says we consider that argument is untenable, and the reasoning is that the class was defined in a particular way and it was clear that deceased persons weren't included. And an amendment then is produced overnight, and you see that at paragraph 43. And the amendment is set out at page 83. And again, what you can see in the proposed amendment at little b, little 1, is just the words added, including persons who have since died. So no amendment is made to the domicile date or suggestions that it was earlier. And essentially, what the court found was that amendment didn't do the trick. And you can see that at paragraph 55 of the judgment at page 86, because it wasn't proposing a claim made on behalf of the estates, and that would have been the necessary form of any such amendment. And the argument is rejected in the passage I showed you already at 59 and 60 on page 88, more comprehensively. So,
and the claim couldn't be brought by the estate at that stage because it was time barred.
it was time barred and the amendment didn't seek to include it. And the time barred point comes in at paragraph 62. And this, I would suggest, is crucial because it had already been rejected on the grounds of nullity, but the court goes on to say it would have been time barred, paragraph 62, recognising at 62 that there was a time bar point pretty quickly on the heels of the claim form. And there was a debate then on which rules apply, which I don't need to trouble your lordship with. And the judgment is at paragraph 72, page 92, records that the application to amend is made after the limitation period has expired, and an amendment to the class definition to add persons who were deceased before the claim form was issued cannot be allowed. Now, you can then go on, and I invite your lordship to read paragraph 73 in a moment, but I should add, I obviously didn't do this hearing, but as I understand it, the same point was obviously applicable to, the court had in mind at this point people who had died prior to the issue of the claim form, and the same point was applicable to those who had died between the issue of the claim form and the domicile date, but the court didn't appear to consider that that point was before it, and made the statement, the finding in paragraph 73, that it was still open. So I invite your lordship to read that. I'm told, my lord, that Mastercard's submission was that it applied across the board, but that wasn't reflected in the judgment.
But I mean, that's simply a reflection that the claim, persons who were alive when the claim form was issued wouldn't be caught by limitation because the claim form was in time.
Well, my lord,
If they otherwise fell within the class definition.
if they otherwise fell
That's
within the
the
class
point.
definition, exactly. So, my lord,
Whereas those people who had already died could not have fallen within the class definition, and therefore couldn't amend in circumstances where their claim would have been time barred because they weren't on any view within the class. That's the point.
that's right. Although, as you've seen, the class representative attempted to argue they were. And now, what
They
then?
wouldn't be in the class, not just because they weren't drafted as such, but because the law prevented those who died before the claim form arising. So
Exactly, and
both
because of the way the class was defined.
Yes.
Exactly. So, my lord, we're now coming up to the end of 2021. There is a case management conference on the 14th of January 2022. And it is only in the lead up to that CMC in 2022 that it is suggested by the proposed class, or the class representative, for the first time that the domicile date should not be the date of the CPO, but the date of the claim form. First time. And this is the point at which an amendment is proposed to include the estates of any individual alive at the date of issue. And if you go to the tribunal's judgment in the main bundle, please, at tab 5, paragraph 8 is the relevant paragraph, and it's the last sentence, two sentences I rely on. However, that is not the way the claim form has been drafted here. Although Mr. Merricks has sought now to amend his claim form, he realistically accepts that if the CPO date is specified as the domicile date, limitation issues preclude an effective amendment to the class definition to bring those who have died since the claim form was issued, but prior to the CPO date, within the class. That is also reflected in the respondent's skeleton argument for this hearing at paragraph 7, at page 73 of the bundle, tab 9. And it's said by my learned friend, it followed from the manner in which the class was defined by reference to persons living at the domicile date that persons who died between the issue of the claim and the domicile date set by the tribunal would fall outside the class of persons. Limitation issues precluded an amendment being made so as to join their personal representatives. So what we would submit, my lord, is the following. There are 4 points. First, prior to the CMC in 2022 and the run-up, neither side ever contemplated that the domicile date would be backdated to the date of the claim form. Significantly, for over 5 years, Mr. Merrick advanced the case on the basis that the domicile date would be set on or around the CPO date, it being said that was the date that made sense, fair and square. In 2017 it was said, recognising the consequences that there would be a group of people not included. It was only after the tribunal refused permission to amend the claim form on limitation grounds in August 2021, with the consequent recognition of the limitation issues more generally, that the approach of backdating the domicile date was first suggested.
They jumped on the hint in paragraph 73.
That's right, that's right. And we will submit, as I'm going to come on to develop, but this is the nub of my submission, that you can see in that context and on the face of the judgment itself and the recognition in my learned friend skeleton argument, that the tribunal's exercise of its statutory discretion was exercised for an ulterior purpose, because it was a direct attempt to circumvent the class definition and the consequent limitation issues. And that is not the statutory purpose of and function of the domicile date, no matter what sympathy the court may have to how one came about to this position. It is not a statutory function. And in particular, it is no purpose of the statutory purpose of a domicile date for it to be used to overcome or circumvent other issues, but particularly, we would say, limitation issues, because you there have a real danger that this regime is going to be unused or seen as being used to undermine the general principles of law that no court would be otherwise keen to undermine, as indeed the CAT's own judgment recognised. Can I then show you some of the passages, please, in the CAT's judgment which makes it absolutely plain that they did recognise that they were going beyond the realms? So if we go back to, it's tab 5 of the core bundle.
First of 4 points.
I'm sorry, those were my 4 points. I should have broken them down. I beg your pardon.
Okay, that's right.
My lord, if we then go to the core bundle again, please, tab 5. And if we can just start with the judgment at the beginning.
Sorry, I'm sorry, Mr. Delaney, that you said there were 4 points, but really you've wrapped them all up into one, have you?
I was breaking them down, my lord. I can break them down for you. The first is that neither side ever contemplated.
Yeah.
The second is that Mr. Merrick personally advanced the case. The
Yeah.
third is that the tribunal refused permission, and that's when
Yeah,
there
that's
was a
when it-
change in
yeah.
case. And the fourth is
Is it
that's the statutory discretion.
Thank you.
I think that's just one big point.
It may be, but those are the steps, my lord.
Yeah, all right.
It sounds better if I say there were 4 points, my lord.
More logical as
More
well.
logical.
Yeah.
My lord, then going on to the judgment, please. You will obviously have read this and identified the background, the issue, and the claim form. And I've shown you the relevant start of the reasoning at paragraph 7. But what's striking here is that you see at paragraph 4, Mr. Merricks seeks a determination that the domicile date shall be the claim form, as if that's always been the case. Now, clearly it hasn't. And you see immediately at paragraph 7, the debate as to the consequences of setting the domicile date on the number of people included in the class. And that's at paragraph 7. And you've looked at paragraph 8 already, the recognition of the limitation issues arising. And then at paragraph 10, we're back to the debate about the number of individuals that will be included depending on the date that's picked. There are various then arguments after the legal framework and the different debates of the council, and I'll come on to those in the context of grounds 1 and 2. But moving on to paragraph 26 at page 42, you see that the CAT looks at the structure of the statutory regime and you see at paragraph 29 the recognition that the domicile date is relevant only for opt-out proceedings to determine whether a class member will be automatically included, unless they opt out, and conversely whether they have to opt in to be a represented person. It serves no other purpose. There is no need or even expectation for it to have a bearing on class definition. We then see, correctly, the heading, the rationale for the domicile date. And again, you see the tribunal recognising that the rationale for the domicile date was to avoid subjecting defendants to claims by enormous international classes. Further, it was not considered appropriate automatically to include people who lacked a close connection with the UK in UK legal proceedings without a conscious decision of the persons concerned. So you see the rationale of extraterritoriality in the passage set out, and the tribunal sets that out. So there is a recognition as to what the domicile date does, but nevertheless, something different is done in this judgment. And if we move then to the context of the present case, paragraph 31, a particular feature of this case is that the proposed class representative chose to define the class by reference to the domicile date. If instead he had defined the class in terms of persons alive on the date that the proceedings were commenced, the issue we are confronting would not have arisen. But of course, we've seen it was a deliberate choice with recognition that it was not intended to include everyone from 2016. So we then go on in the judgment to look at the consequence, which is paragraph 36. This is what at page 45. And this is under the heading, the interests of justice. As set out above, the reason why Mr. Merricks seeks specification of the claim form date is because some 3 million people with valid claims will have died and would otherwise be excluded. So that is said to be the justification for a different domicile date. And you then go to paragraph 40, and that's on page 46. For all of these reasons, we determine that the domicile date should be specified as the claim form date. However, we've reached this decision on the particular circumstances of this case. We consider that for CPO applications in the future, it is undesirable for the class definition to depend on the domicile date. And then this crucial last sentence, the two concepts should be kept separate and the domicile date limited to its particular statutory purpose. So here you have a recognition that what the tribunal has done is not to limit the domicile date to its particular statutory purpose, because in the circumstances of this case, they have done something different to meet the perceived position under the case.
What the cat might equally have said in paragraph 36 is that the reason why Mr. Merricks seeks specification of the claim form is because 3 million people with valid claims will be excluded because the cat got it wrong first time around. And that's why this has happened, isn't it?
Or the cat might have said in its judgment, if the claim form had been issued not 5 days before, so there was time to amend, then notwithstanding the time it took for the decision to be made, an effective amendment could have been made. This class of people, their tenure ended in 2008.
The people who are, as a result of the CAT judgment, included, which is to say people who were living in the domiciled in the UK in 2016, but are now living abroad. If the CAT got it right first time round, and the domicile date had therefore been the date of the CRO, I mean, leaving aside the 6-month point, the fact of the matter is that the vast bulk of those people would be validly within the opt-out regime, wouldn't they?
Well, my lord, I'm going to come on to this because it's very beguiling to say 3 million people are excluded by the result of this delay. But of course, what the CAT's done isn't just to pull in the 3 million people it says have been excluded. Its judgment has had consequences on excluding people who would now be included.
Who are they?
Well, because the CAT has made its decision from the date of the claim form, there are those people who are now living in the UK with a valid claim who are not automatically caught
They're going to be
potentially.
pretty few and far between, aren't they?
Well,
I mean, the hypothesis for that is a whole load of people who were living in the UK at the time when the offending MIFs were charged, which is between, I forget the date now, but 1992
92 to 2008.
and 2008, so a long time ago. They then move abroad and then they come back. So I mean, I suppose there
It's
is
quite
some
possible.
suggestion that people who went to Spain have come back, but
Yeah.
there aren't very many.
Yeah. But the point is that there are 2 points, aren't there, my lord? One is that my answer to my lord and Lord Justice Mayles about when this claim was started and pleaded is a valid one because the group of people were known by 2008. And so the consequences of the delay didn't necessarily have to be what they were. But the second is that the mischief of using the domicile date is that you don't know who's now included and who's not. And the whole point of this is not, the domicile date is not a way of giving redress to consumers where the claim has not been pleaded in a particular way. The domicile date's function, statutory function, is simply on territoriality. And doing what the CAT's done ignores that function and is mischief because it directly cuts across the statutory purpose for consequences this court doesn't know and prejudices potentially other groups of consumers.
That might depend upon our view of the statutory purpose.
Indeed,
You've
and I'll come on
taken
to that.
a little slither of opt-out, opt-in policy, if you like, and said, here's a little rule, that's its purpose. But your argument has to rest upon the assumption that's the only optic through which we examine the facts. And we don't, for example, take either the wider policy objectives behind opt-in, opt-out, or even the broader objectives behind the regime as a whole.
Yeah, and I'm coming on to that, my lord, because I understand that my learned friend's main point is the collective regime approach is to give redress to consumers, and in the interests of justice, therefore one should try and include as many people as possible. That's
And there's perhaps
key
an
point.
intermediate, which may be not very dissimilar, but it's focusing upon just general considerations affecting the discretion about opt-in and opt-out, of which this is one subset.
So I'll come on to those in a moment. What I was going to do next, having shown you the judgment, is briefly to address you on the law. I don't think there is a lot between us. The point taken by my learned friend is that this is all a matter of the tribunal's discretion. It's not a point of law. And we say, yes, it is, because we are saying not that the tribunal should have ordered 3 years rather than 5, but that they exercised it for an ulterior purpose, not in accordance with the statutory function, and therefore it's a point of law.
So it boils down to
That ties in with the same point as my lord's just made.
Exactly.
Depends on how we,
Depends on how you characterise it.
what view we take of what the statutory purpose is to be.
That's right. But the claim form point, the construction of a claim form is, I think,
But I think the point is, isn't it, that you may be right that the domicile date itself has a limited function, if you like, within the regime. But what the tribunal is really doing is looking at how the regime is intended to operate as a whole, and that's all part of
well,
a
maybe.
broader picture which they're entitled to take into account, aren't they?
Well, not if they say it's about the true function of
Well,
the
they may-
domicile date.
Maybe they misspoke.
Indeed, my lord, but looking at what they said, I can only say that what they said in our respectful submission is wrong. So, my lord, just looking then at the principles of law,
Yeah. Yeah, what do you want us to look at?
my lord, it's common ground, I think, between us that the under the Competition Act, an appeal arises on a point of law from the decision of the tribunal, and the relevant principles are addressed in paragraph 21 of our skeleton on statutory discretion, and the relevant extracts are set out.
Hang on. Paragraph 21.
Paragraph 21.
Right.
And I fully appreciate, I'll take this quickly because each of the court is very familiar with these principles, that statutory discretion must be exercised consistently with the objects and scope of the statutory scheme.
Yeah.
Now, tab 11 of the authorities bundle, my lord, is the ex parte world movement case. A decision of the Court of Appeal. My lord, the case concerned a decision by the Foreign Secretary to grant UK government aid to a project in Malaysia under the Overseas Development and Cooperation Act 1980. And a provisional decision was made to support the project pending a full economic appraisal. The appraisal concluded that the project was uneconomic, but the Foreign Secretary decided to approve the aid in any event to avoid undermining the government's credibility. And it was common ground that the Foreign Secretary had discretion to approve aid proposals or not. And the relevant issue for the court was whether the discretion was unfettered and allowed the Foreign Secretary to proceed with projects even if they were not economic. And the relevant passage that we've cited is at page 398 between letters B and C. True purposes and the reasons which are relevant and proper. And it's quite a strict statement of the statutory function. So here, although looking at the scheme in the round might have allowed the consideration that you don't want to undermine foreign aid and credibility, looking at the strict statutory function, the court said that the Foreign Secretary was not entitled to exercise their discretion as they had. And we see similar statements in the case of tab 12. And in particular, the passage at paragraph 105, which is at page 290. 299, I'm sorry, it's 290 of the law report, 299 of the bundle. 299 of the bundle.
105.
Yes. Now, here, taking my Lord Justice Green's point, the discretion in the setting of the domicile date, we would say, has to be looked at in that lens. What's the discretion in relation to the domicile date for? It's not the discretion in relation to the regime as a whole. It's not a discretion generally as to the interests of justice and the operation of the scheme as a whole. One has to ask, what's the discretion conferred for? What's the purpose? And that in itself brings into the inquiry, what's the function of the domicile date? And the submission I'm going to be making to your lordship, in light of particularly my Lord Justice Green's comment, is that you have to first of all rigorously look at what the domicile date is there to do. And then the discretion must be in relation to that function, not to capture lots of other extraneous considerations in the interests of perceived interests of certain consumers at the expense of potentially other consumers.
As defined in the statute, the discretion is untrammeled. There's nothing in the statute which directs the court as to how the discretion should be exercised.
That's correct, my lord.
You have to infer the purpose, as you've done from collateral documents, admissible collateral documents. But is it relevant that Parliament did not lay down any restriction on the matters that could be taken into account? Which it could have done.
It could have done, but the reason it may not have been necessary is that the Parliament made it clear what the function of the domicile date was, which is extraterritoriality. And so it had at the discretion, I would respectfully submit, has to be relatively limited because the domicile date actually has only a very limited function.
But it also has the effect of, in practical terms, of removing people's rights or fettering their ability to have access to a court. It has those consequences.
It does have those consequences, but it also, the main consequence that Parliament was concerned about was imposing this court's reach on foreigners. And I'll come on to address you on this, but that's precisely what the effect of this order does, and it's wrong.
That's because some of the people who were domiciled would have moved abroad.
And vice versa.
And vice versa. There's still a connection with the UK. It's not as if one's saying in the class that we'd rather like anybody in the United States to have a right.
No, but the
They've got
domicile...
no connection. There's still a connection.
But the domicile date's function is being stretched beyond its actual purpose.
That's the key issue.
That's the key issue. And that, I would say, has been recognised by everybody, because you've seen the statements made by my learned friend's side. You've seen the statement of Mr. Justice Ross saying, well, in 2021, well, obviously the domicile date's going to be 2021. And you've seen Mastercard's continued position that it would be the CPO date or around that date, and all the other 7 cases in which that's happened. So we would say, as a starting point, nobody in this court can suggest that the domicile date hasn't been stretched, because nobody until 2022 was suggesting it would be the claim form date.
There's going to be a degree of leakage, whatever rule one applies, so that even if, on your analysis, the domicile date was fixed at the same time as the CPO, and let's say the litigation, because it's very complicated, took 3 years, there would still be people who, during that period, would move abroad and who would be beneficiaries of the claim.
There would be leakage.
It's just it's a question of degree here.
It's a question of degree, and it's a question of recognition here that the domicile date has been used to overcome other issues. And the question for this court is, can the domicile date and its concept be stretched that far when even Mr. Merricks didn't take that point until the very last ditch because of limitation?
That's extremely irritating for you, but it's a question. That is a discretionary matter for the tribunal.
It is, and I'm not...
Irritating exercise of discretion, but a discretion nonetheless.
And I'm not suggesting even that it's irritating, because we are where we are, but what I would say is that this court has seen many limitation issues, and one could say the same thing. One could say in many cases where claims are statute barred, it's unfair, that's outrageous, can we get round it? But this court doesn't take that approach. And to use the domicile date to circumvent a limitation issue, which existed...
Well, the claims wouldn't be time barred, would they, if the individuals in question, if you're right?
Well, some of them would.
Those people who were domiciled in the UK as at the date of the issue of the claim form could still opt in, couldn't they?
Well, my lord, if, at the time that the claim form was served, it was suggested that those who'd passed away between the date of the claim form and the domicile date, which was indicated to be 2017, weren't included. The effect of backdating is to even cut across what was the intention in issue in the first place. Now, that may be only 6 months worth, but the fact is,
the effect of your argument, as I understand it, let's assume that you're right, and that the domicile date should be at some date in 2021. Is that those people who at the date when the claim form was issued were domiciled in the UK and therefore capable of falling within the class, but who have now moved abroad,
yes,
would not be within the class for the purposes of opt-out.
that's right.
But they could still
They could
seek
still opt
to
in.
opt in.
Yeah.
So it's not a limitation point, this, at all. Because it's not being suggested that people whose claims would otherwise have been time barred are being allowed back into the class. I mean, that's just a false point in respect.
Well,
Because this only covers those people who were capable of being within the class when the claim form was issued.
but you need the
Mr. Merricks tried to include a whole load of other people who died previously and failed for obvious reasons.
That's right, but now he's trying to include a whole load of people who've died since.
Yeah, but they were capable of being within the class when they were domiciled in the UK as at the date of the claim form.
Well, the ones, yes, except that Mr. Merricks had accepted on the service of the claim form that at least some of those wouldn't be included because of paragraph 23D of the claim form.
Yeah.
But if you're right, these people, the estates of those individuals could opt in.
But that if you remember 23D, if you remember from the judgment
Oh, yeah, I
of the
understand.
paragraph,
I
said
understand.
expressly excluded those
I
estates.
understand that.
So all I'm saying to you is,
All I'm doing is trying to probe whether it's really a limitation.
well,
point.
my lord,
As you say.
I fully accept that if you set the domicile date as a particular date, then you circumvent the limitation problem, so there's not a limitation problem. But that's a circular point. And that's why I've not put my case any more highly than I'm showing you how we got here, which is because of this looming limitation point accepted on the face of my learned friend's skeleton, a different approach was taken. And that's why I'm saying to you that everybody recognised the domicile date was used in a particular way to avoid any limitation issue arising now.
Once you're over that, coming back to the question of the statutory purpose, the tribunal then looked at this issue and said, all right, on your view, these people should be required to opt in, these categories of estates or people who were abroad.
That's right, but estates couldn't then, without the amendment.
Without the amendment. But in principle, or at least in theory, they might be able to do so. So doesn't that then engage the cat's discretion as to the circumstances in which people ought to opt out or opt in? One moves beyond just deceased people and extraterritoriality. You're looking at a different issue. Should we impose upon this category a duty to opt in, or should we allow them to be opt out? I mean, that you're into a different, policy-based analysis.
But maybe, my lord, but whether there should be a policy-based analysis is a real question for your lordship, because the domicile date is actually, I think, supposed to take away the concept of policy. It's just a clear date, and those resident in the UK opt in, and those are in unless they opt out.
You have to. That's putting the cart after the horse. This factor goes into when you choose the domicile date, and the question is whether they're entitled to look at the effects, the consequences, beyond just extraterritoriality. They're entitled to say it's extraterritoriality, but also the burden we then impose upon people to opt back in. It's a more multifaceted decision.
So, can I address you on that?
Yeah.
But before I do, can I just come back to you on your unfettered point?
Yeah.
The case I showed you was about data protection. And in Data Protection Act cases, the discretion is also not prescribed,
Which
as I
cases are
understand
those?
it. It was the chain gardens. The discretion is itself not
Oh yes, I remember.
trammelled by Parliament, and yet the court concluded that the discretion couldn't be just general and untrammelled. So on your point about the Act not saying when you exercise a discretion, I think the same could be said in the context of this case, and yet it was approached on the basis you have to ascertain the purpose and it isn't unfettered.
Which, that's paragraph 105.
And then we obviously have the other statements in the bundle, my lord, on the same sort of point. The Stewart and Perth case on the discretion and a licensing authority. This is, the extract is at 21D of my skeleton. The discretion which is vested in the licensing authority is not unlimited. That authority is not at liberty to use it for an ulterior object, however desirable that object may seem to be in the public interest. And the well-known statement of Lord Bingham in the Porter case, that you can't go beyond the function. I know my Lord Justice Green and the Chancellor sat in the Beattie and Patterell case, which of course we also rely on. And in particular, and that case is in the bundle, I think, at the last...
Tab 15.
Tab 15, at the last tab. And in particular, we rely on paragraphs 50 to 57.
Paragraph?
50 to 57, in which your Lordship outlined the scope of the appellate jurisdiction and identified various points of law.
Yeah.
And taking the easy one first, which is the proper construction of a document, that's paragraph 55, we say the claim form falls within the scope of that, plainly. As to the discretion point, it's not within one of your categories, but is plainly, we say, if issued for an ulterior purpose, a ground of law. Alternatively, we suggest it's in your third category at paragraph 55 as well, in relation to the overall high-level approach. I fully accept, my Lord
I
Justice.
suppose the categorisation of the purpose behind legislation is clearly a point of law.
Exactly.
That's
So
fair.
it comes down to whether you're with me on the statutory purpose at that point, but the construction of the document is plainly a point of law either way.
Difficulty with construing the pleading in the context of CAT proceedings is that these things change with permission. The question is, what's the materiality or impact of something like that, which can change rapidly and
Well,
dramatically before you get to the renewal
I'm
trial?
going to make that point to your Lordship because the idea of the clear intention and that being relevant seems to me not right in the first place, but if it was relevant, they got the wrong intention. That's the submission or granting. So, my Lord, that's very briefly the point of law. So can I turn then to the statutory discretion? So can I start with what's common ground and some of these points we've already identified. The first is that Rule 181G of the CAT rules requires the tribunal to include a domicile date in the Collective Proceedings Order. The second is...
Sorry. Just repeat that.
The first point of common ground is that Rule 81G of the CAT rules requires the tribunal to include a domicile date.
Yep.
And I can give you, just to make this good that it's common ground, the references in my learned friend's skeleton.
Mm-hmm.
So that's paragraph 13. The second point, which is common ground, but I'll be correct if it's not, it is that the purpose of the domicile date is to determine whether a person who falls within a class definition is domiciled in the United Kingdom, for the purpose of them being automatically included unless they opt out, or whether they will be included if they opt in. And you can see in paragraph 12 of my learned friend's skeleton the reference to rule 73(2) of the CAT rules, defining the domicile date as the date specified in a collective proceedings order or collective settlement order for the purposes of determining whether a person is domiciled in the United Kingdom. The third point of common ground, which my Lord Justice Green's already put to me, is that the rules do not specify the domicile date, i.e. what it should be, or include any express criteria for determining the correct domicile date. And so I accept that the tribunal has a discretion and that there is a possibility that the domicile date may be different in different cases. And the starting point, therefore, of the appeal is that I accept there is a discretion. But my crucial submission is that it is clear that the tribunal's discretion cannot be unfettered, and therefore I think, as the court has already identified, the real question for this court is how does the tribunal, exercising the discretion in accordance with the statutory purpose, set the domicile date? And I agree with my Lord Justice Green that in order to answer that question, the foremost question is to look at the statutory purpose of the legislation. Now, the statutory purpose we submit is to ensure that the court does not assume jurisdiction over individuals domiciled abroad unless they specifically consent by opting in. And the legislative rationale is to avoid objections based on national sovereignty. And the tribunal recognised at paragraph 30 that the whole concept of the domicile date is to ensure only individuals domiciled within the jurisdiction are caught by proceedings without giving their express consent. Now, we say that if you take that as the clear statutory purpose, the tribunal seemed to accept that, my learned friends seemed to accept that, certainly her predecessors did in the documents I showed you, in particular the skeleton in 2017. It follows that the domicile date should be linked to the time at which the tribunal takes jurisdiction over a class. And that is particularly the case given that people do move in and out of the jurisdiction. And it's why typically, as we've seen in the other 7 cases, the domicile date should be set on or around the CPO date. And it's why in 2017, Mr. Merricks' submission was that's the date when the actual class is apparent. And we say that fulfills the statutory purpose of the legislation because the tribunal is only taking jurisdiction in relation to people who live in the UK at the time when it assumes jurisdiction, or by people resident abroad who specifically consent to the proceedings by opting in. That also fits with the notification regime, because if it's close to the domicile date, if the domicile date is close to the date of the CPO, those who live in the UK at the time of notification of the proceedings, which hasn't happened yet, takes place, they can be presumed to be aware of it and exercise their right to opt in or out. In addition, we say here, since the class is defined in terms of those living at the domicile date, specifying the domicile date as the CPO date means that most of those caught in the class will be alive when they have to take the decision to opt out or opt in. And that's more desirable than if a claim form date is set, because 5 years is likely to mean a number of deaths leaving the elections of personal representatives.
Does anyone really dispute this? It was Mastercard's legal team's brilliant representations to the tribunal that induced or seduced them to decline jurisdiction, then led to 5 years. delay before there's the remittal back for a new CPO. If things had gone to plan in accordance with Mr. Merrick's expectations, the domicile date would have been fixed at or around the time of the CPO. Comes back to the point the Chancellor made at the outset. Isn't the real thing that went wrong here the cat's first judgment?
Well, my lord, if I had been Mastercard's advocate, I would absolutely agree with you. But as I wasn't, I can't comment on what happened the first time around. But what I can say to your lordship is, in a sense, using the domicile date to correct a bad judgment, would we say the same thing for all sorts of cases? That it just isn't the right use of the domicile date. That's my answer to you. And the second is that you're right to say that everybody expected the domicile date to be set as the CPO date. That's what we've seen in all the documents, because that's the right date. And it doesn't matter now whether or not the date is shorter or longer. The explanation given by my learned friend's side back in 2017, as I showed you, was that's the date when the actual class is known, as this is the point at which there is an actual claim that is proceeding before the tribunal in which the class members are included. So that is the rationale for the CPO date, and the fact now it's going to be later doesn't change matters. And it isn't just because of the CAT's decision. This is an important point. It's because of the way Mr. Merricks chose to draft his claim form. So your
The CAT could have said at the time, well, it's all very well the way you've drafted it. We're going to exercise our discretion as to how we set the domicile date, and we're going to do something slightly different.
Well, they could have done, but they didn't. And the fact is, we don't normally use statutory legislation, which actually has a very narrow compass of function, I would submit, to correct bad drafting or incorrect drafting, whichever it was, and a decision that was made that was then not upheld. That's precisely why I'm saying to you that there's an ulterior function. You may think it's unfair, but the domicile date has actually got a very narrow compass. And once one uses statutory objectives to reach fair decisions, then there's no point having the statute.
It looks as if the choice with which the CAT was presented was between the claim date and the 2021 date.
That's right.
When the order would be made. And there doesn't seem to have been an argument that they ought to take the 2017 date when the order ought to have been made.
Well, that's.
And if they had, I suppose you would have the same arguments, would you? Except the consequences would be less because it's a smaller time gap, and therefore fewer people are going to be affected by the difference between 2016 and 2017 than are affected by the difference between 2016 and 2021.
And you accept the at or around formulation?
I do.
Claim form in 2016, CPO 2017, is that at or around?
Yes, it was. Because it was at around the CPO date, not the claim form date.
Normally you'd expect something like Mr. Merrick's expectations would happen. You either fix it to the claim date or you have the CPO hearing relatively shortly thereafter, after the claim is in existence. So at about that time there will be a domicile date fixed.
Well, my lord, usually I don't think it's typical that the claim form date and the CPO date match, or there is a gap. We say at around the CPO date because there may be a gap between when the court decides to assume jurisdiction and when the actual CPO order is made. And that's why we've used that formulation. Because the key point is it's when the court assumes jurisdiction. And that's when you kick off the class, the claim, the notification.
There's no prohibition though in the CAT's rules against fixing it as of the date of the claim. I see the logic of perhaps CPO being the pivot about which most of this turns, but that may just be a normal position or presumption, it may not fit every case.
Well, my lord, I would say there's no prohibition, but it goes against the statutory purpose, because the point is that this is not the function of the domicile date is not to ensure that everybody who might have a valid claim is included. If that were right, why not fix the domicile date, as Mr. Justice Ross said in 1992 or 2008? Why wouldn't the people who died before the issue of the claim get the same treatment as the ones afterwards? Where does it end?
Pragmatic choice between 92, 2016 or 2017.
Well, 2017 wasn't on offer and 1992 was disavowed, but 2016 is just a random date picked because, as I've said, of this limitation issue and the drafting. The reality here is that the CPO date is never going to be the claim date normally. Sorry, the CPO date is never going to be the claim date because you issue the claim and then there's a process by which the court considers whether it should take jurisdiction. So it's naturally going to be later. And it's the date of jurisdiction for domicile, and it is called the domicile date. It's not called the date at which people make claims or the collective proceedings date. It's called the domicile date because it's when the court takes jurisdiction, and as at that date, it's who's domiciled here, that is they're a court without their consent into a class action, which they're going to be bound by with no ability to contest it unless they actively take steps. That's the point. So using the domicile date to fix the class is absolutely the wrong approach, even if this court, which I appreciate, and I appreciate the CAT's position in trying to fix it, but I do also think it is instructive to this court that Mr. Justice Roth said rather sceptically, well, you're not expecting it to be 92, it's obviously 2021. And everybody proceeded that way. And it was only when Mr. Merricks said, oh dear, we're going to lose lots of people because of the CAT's decision, that somehow things change. And that's not the way the statute's supposed to operate.
The CPO validates a claim. So in terms of jurisdiction, certainly at the date of the CPO, jurisdiction is established. Jurisdiction is established to triumph a claim, which predates the CPO. So it's 6 of one, half a dozen of the other.
The statute could have said the domicile date will be the date of the claim. It didn't.
Good.
It's tied to, this, as the tribunal set out in paragraph 30, jurisdiction over people in this country. And what I was going to say to you is, I accept that once you say the tribunal's got a discretion, and you can say, as I have said, and I don't think there's any real contest, that the usual assumption would be it would be around the CPO date, which is precisely what we said. You might then have to look at the reasons why it might not be. And I accept that. But the reasons it might not be are, for example, if there's a reason, as my Lord Justice Flo posited, but there's no evidence in this case that people hadn't left the jurisdiction, or there was a delay over notification, it might be set further in the future on the basis that then the notification process would take place. So there may be scope for some adjustment. What I would say to you here, though, is this is 5 years. 5 years. That's got a pretty remarkable order, and I'll show you the reasoning of the tribunal, and it doesn't stack up as good reasoning. And we actually say, when you're talking about 5 years, that is a perversion of the legislation, of the statutory purpose. And what we say is the result is that a significant number of individuals will be wrongly classified as having to opt in or opt out, because a vast number of people caught by the order will be foreign domiciliaries who won't take any part in the proceedings. And equally, a large number of individuals here will not have the benefit of the order and may never opt in. And the tribunal recognise this in paragraphs 10 and 34 of their judgment.
Who are they? They're people who weren't domiciled in the UK as at the date of claim form, but have become domiciled since, or what?
Well, my Lord, people move in and out, so I just look at exactly what the tribunal found, so I don't go beyond what's before you.
It's only people who've moved in and out. It's going to be people who, because by definition, you're only looking at people who are domiciled in the UK anyway.
That's right.
So you look at that at the date of the claim form, and then people move abroad subsequently.
That's right.
And then come back again.
Some do. I mean, people move
All
in
around
and
the time
out.
of Brexit and the pandemic.
My lord, people move in and out of the jurisdiction. This is but my point is, this is not a provision to fix.
I'm just challenging your submission that there's a significant number of individuals who've been wrongly classified.
Well, paragraph 34 of the judgment, given the vast size of the class in these proceedings, there is likely to be not an insignificant number of people who were domiciled in the UK in 2016 but ceased to be so by 2021. And then, insofar as those people otherwise fall within the class definition, specification means, although now domiciled abroad, they would be automatically included in the proceedings unless they opt out. They say here that they think some people, the vast majority of people, won't have changed.
Well, actually, I mean, it's put in a slightly tortuous way, but where you get to is really the last sentence.
Yes, right.
So what they're really saying is, yeah, well, okay, well, in theory there are all these people, but the reality is that unless they were actually domiciled in the UK between 92 or at some point between 92 and 2008, they're not going to be making a claim anyway. So, and hence, most of the, or the way they put it is the great majority of those people won't have changed their domicile.
But then if you look at paragraph 10, my lord, as well, on the other hand, 4 lines down, the practical consequence of specifying the domicile date as the claim form date is that a not insignificant number of people who are no longer living in the UK will automatically be included in the proceedings, whereas those now living in the UK but were living abroad at a time when the claim form was issued will need actively to opt in. So, and what I would say, my lord, is your lordship's approaching this on the basis of why does it matter, how many people really move, do they come back? But with respect, my lord, is approaching it through the lens of how do I get the fairest class?
No, I'm
This
fine.
is
The
all
point
about the
right about statutory, your submission in relation to the statutory purpose. None of this matters.
Well, but if this is all about a domicile date and when people are domiciled, my simple point is if you're going to have a domicile date that's supposed to catch people in the UK, you set it at the time when you assume jurisdiction, because then it's going to actively, then you've got the snapshot there and then of who's in the UK. If you do it 5 years earlier, you're opening yourself up to the position where inevitably there will have been changes. And that people who were not intended to be caught by the legislation are caught, and people who should have been caught by the legislation are not, because there's a 5-year gap. That's the nub of, that's as far as I think I can take the point, because we don't have the statistics over precisely who moved in and out. My lord, is that a moment? I understand there's got to be a transcriber break.
How long is this appeal going to last? I mean, true it is that in appeals of more than a day, we normally have a break, but I did rather balk at the suggestion that somehow there had to be a break in a relatively short appeal. But,
My lord, I'm content to carry on. I'm simply raising if your lordship.
well, it may be that transcribers want a break. What have we got? We've got Opus 2.
Yes.
Well, their resources normally allow them to have more than one person, so that we don't need a break, but there we are. We'll have a break till just after 12.
What lines? typically, yeah, yeah, I typically,
That will be a discussion for later.
are there still some people outside?
Yes, all of their side is outside.
Yeah, I agree. Really?
Yes.
Another one?
Yeah.
Is that number 3?
Yeah.
So you never change? Courthouse.
My lord, the tribunal suggested their order was justified in the context of the present claim, really for 3 reasons as far as we could ascertain. The first was because of their construction of the claim form, which is our ground 2 and I'll come on to separately, and we say was a wrong consideration in any event. That leaves our second and third reasons, which were essentially as to the drafting of the claim form and the class. That's why we say it was, as I've already said to you many times now, done to really overcome specific issues on the face of the claim form.
Yeah.
My lord, what they said in their reasoning probably is worth me just touching on, and that starts at paragraph 27 and 28 of the judgment. Sorry, that's my skeleton. In fact, if we start, it's actually paragraph 33 onwards. And my lord, what the tribunal seemed to have in mind was that the size and composition of the class needed to be identifiable at the start of the proceedings, and therefore it was undesirable to have the class dependent on whether certain criteria were met on the domicile date, because then you wouldn't know when the proceedings were started the size of the class. And that was a justification given for backdating, and you can
So
see.
where's that?
I think, my lord, the best place to pick that up is paragraph 33.
33. Thank you.
And at paragraph 40 is where they say it was undesirable. But answer to that is, you can't retrospectively remove uncertainty which existed in the case of 2016. And therefore, although it's presented in an extremely logical way, thought through, it doesn't actually fix the problem, we would say. That really leaves the tribunal with the one point, which I think is the same as my learned friend's main point, which is that it's unfair to exclude individuals and that it's in the interests of justice to allow the claims to be brought by those who were alive in 2016 as at the date of the claim form. And the answers to that are, first of all, I'm conscious I've made these points, but first of all, that is the product of the drafting of the claim form, and it's something Mastercard said repeatedly during the course of the proceedings, and it's something that was appreciated, see paragraph 23D. Now, it may be more extreme because of the delay in the proceedings, but logically giving, and this is my Lord Justice Mayall's point, I think, giving backdating to 2016, which is not what anybody anticipated, even Mr. Merricks, on the face of the claim form, is inherently illogical. The second point is the limitation point, and I should just clarify, my Lord, I know my Lord Justice Flo has this, but obviously the limitation point really only applies to those who died, that otherwise the jurisdictional point is the point your Lordship made. And the third point is that the desire to include other claims, we say can't justify using a very narrow concept of domicile date to generally bring about justice in the collective proceedings regime. And the reasons for that are, first of all, a deliberate decision was taken in the legislation for reasons of jurisdictional proprietary comity to limit the jurisdiction of the tribunal to UK residents and foreign residents who choose to opt in. That's what the domicile date's doing. The general purpose of the regime to facilitate access to justice can't trump what we say is a specific limitation on the jurisdiction of the tribunal. And that's the answer, I think, to what we would say to my Lord Justice Green's point as to why isn't the statutory regime wider. Well, the concept of domicile date is in the legislation for a reason, and it's for a limited reason. If there are other ways of providing access, so be it, but this concept shouldn't be stretched to breaking point, which is where we say it has been, and in particular to the 2016 date. My learned friend relies on, I think, Rule 4 of the Tribunal's rules, which is that the authorities bundle tab 3. Turn this up.
Yeah.
And also, I think, your Lordship's judgment that in the Patterell case, that the tribunal shall seek to ensure that each case is dealt with justly and at proportionate cost. But I think the short point on this is, of course, the tribunal has to deal with a case justly. But if you look at Rule 4.2, it's really dealing with matters of case management. It's not trying to say that jurisdictional limits imposed by Parliament should be stretched to meet whatever interests of justice the tribunal perceives or doesn't perceive. And if justice was being done in this case, then one would have to have regard not just to the interests of the people that have been potentially identified as falling within the pool from 2016, but actually what's said in the claim form about those who were never going to have the claim, what's said in the claim form that meant the problem arose, and all the people who will be unaware of the proceedings, who will now be living abroad and unable to opt in, who would have been able to, or vice versa, and Parliament's intention as to extraterritorial reach. So one has to balance the exercise instead of just simply doing what we submit the tribunal did, which is simply to say, recognise the statutory purpose, but here this case is, we ought to make an exception.
Parliament could have said that the domicile date should be the claim date or claim form date or something of that kind.
Yeah, it could have done.
If what it was seeking to do was to say, well, I mean, I think it all depends on what you take a very narrow view of the statutory purpose, but if the intention was, which I think is your case, that only those people who are domiciled in the United Kingdom as at 2021, even if they were domiciled in the United Kingdom in 2016 but have now moved abroad, and the Parliament was not intending to as it were take jurisdiction over people who now live abroad. Parliament could in fact have defined the domicile date more closely than it did. I mean, it didn't say when it was to be, it gave the tribunal complete discretion as to fixing it. And whenever it's fixed, it only covers those people who are domiciled in the United Kingdom as of that date.
It does.
So it does achieve the statutory purpose in that sense.
Well, it does, but that's
And
why.
subverting the statutory purpose, as you put it, would really involve the tribunal saying, for example, never mind all that, we're going to sweep up everybody, including all the people who live abroad. Now that obviously would be completely contrary to
Well, but in a way they are, because if the people who were here at 2016 have moved abroad, they are sweeping them up. That's the point. And that was...
They've still been domiciled at some point. I mean,
Yeah,
it comes back to what the purpose is. I mean, we've referred to Parliament's purpose. To discern Parliament's purpose here, are you just relying upon what the CAT said about the purpose? Or your, if you like, common sense forensic inference to be drawn from the language? I'd seen a reference somewhere to one of the consultation papers, but I'm trying, what do you say is the material from which you should deduce Parliament's purpose? Is it just common sense, or legal common sense, if you like? Or is there some document or statement by...
So, my lord, I'm looking first of all at the language of the statute and what it's trying to achieve, and we can just go through that. And paragraph 30 of the judgment, which refers to the consultation that your lordship had in mind. And what I would say is that we can look at what the judgment says about the statutory purpose, but there's no respondent's notice suggesting it's wider. What's said is the discretion. It's relying on the discretion of my learned friend's case. And on the statutory purpose, so if we look in the authorities bundle at 47B, and that's tab 2, and it's set out in the judgment at paragraph 12 as well. So collective proceedings are to be made only if the tribunal makes an order. And then section 11 over the page, opt-out collective proceedings are collective proceedings which are brought on behalf of each class member, except any class member who opts out by notifying the representative in a manner and time specified. And B, any class member who is not domiciled in the United Kingdom at a time specified, and so on. And then 47B12, where the tribunal gives a judgment or makes an order in collective proceedings, the judgment or order is binding on all represented persons.
I mean,
And then,
part of the difficulty is if you go back to, if you look at paragraph 30 of the tribunal's judgment,
yes,
second sentence, it was not considered appropriate automatically to include people who lacked a close connection with the UK in UK legal proceedings without a conscious decision of persons concerned. That, in one sense, begs the question as what's meant by persons with a close connection with the UK, because if the people in question were domiciled in the United Kingdom when the claim form was issued, then they did have a close connection with the UK. So there's no question there of subverting the statutory purpose, if that's the, as it were, the statutory purpose in question.
well, can I push back on that, my lord? It seems to me that the close connection is domicile, when we're talking about a domicile date, and domicile being something that can change over time. That's why the logic is that you are pulling in people as at the date you assume jurisdiction when they are domiciled in the UK.
That also begs the question with respect, because what the statute says, as I understand it, is that the claims continue on a collective basis with opt-out, which is recognising that the jurisdiction is founded by the issue of the claim form.
Well, my lord, I think Lord Justice Green...
Which is Hornbook law with respect.
Well, I think there is a point about people who've opted in can still move out of the jurisdiction, and people who weren't caught move in to the jurisdiction. But the point is, there's got to be a moment in time when the jurisdictional reach of this court is set. And the logical date for questions of domicile, when you're talking about the rationale being not to catch people who don't live here, the logic must be that you assume jurisdiction at the closest date, the domicile date, so that you know who you're catching, and that's when, rather than setting a date 5 years ago, which by definition means you don't know who's moved in and out since.
That might be a very good exercise of discretion. You have to say that's the only exercise of discretion possible, and that no other permutation would be lawful. And I'm just looking at paragraph 30. From our point of view, we have to define purpose. So the starting proposition is, what do the words of the statute say?
Yes.
We accept that even if they are untrammelled, there must be some limits. So the question is, second stage, what are the limits? The CAT referred to the government's response to the consultation paper, and that falls within the class of admissible documents traditionally that a court would look at. Paragraph 5.56 is fairly broad brush. Government recognises industry would have concerns if anyone in the world could bring a claim. Claims concerns would be exacerbated if there was double recovery, and I don't think the CAT's judgment would offend against that. It's not anyone in the world, it's someone who had a domiciliary connection at some point. We're not talking about double recovery, that doesn't give rise to a risk. They then cite the Civil Justice Council, desire to avoid arguments in relation to national sovereigns if in case of foreign domiciliaries no active part. Well, possibly that supports your argument,
It does.
but it's very broad brush. These are people who had some domicile connection at some stage. And then 557, where the government seems to link it to claims. Again, one shouldn't read too much into it. It's a fairly sweeping observation, but it's
Well, except
none of this provides very, very precise guidance as to what it is we're looking at on these facts, where the excluded class you say should opt in have been domiciled at some point, or are capable of being domiciled at some point, and are, if you like, the exceptions to the rule. The rule is they should be domiciled now, limit exceptions which apply in every single case. Even on your analysis you can have trickle out, people leaving the country, people dying and so on.
Well, you can, but not 5 years worth.
Not 5 years, so that's a question of degree. The question is, in their discretion, even taking account of these sorts of concerns, was the CAT acting within the scope of that discretion? Now, you've got to say that that discretion is very, very limited, must be around the CPO and nothing else, and that it cannot extend anything anywhere beyond that. I don't get that from 556.
I don't think I
I'm not certain I get it from the statutory language.
I don't think I have to put it that extreme, and I don't. What I say is that I accept there's a discretion, and that typically it will be around, the exercise will be around the CPO date, because logically it should be
That's a
when
jolly good starting.
That's right. So you have to then look at why it wouldn't be. And I've given you some examples of why it might be set, for example, a few months in the future, because there's a problem with notification, or there's an amendment being made that would change the class that's permissible for limitation reasons, so there's no limitation issue, and therefore it's said that the CPO date should allow that amendment to go through. I can see that. Backdating it as the tribunal did, not because of the statutory purpose, but to overcome exterior issues.
You keep saying this, but with
It's the
respect,
but
that's
the
not what they say. If you look at paragraph 39, they have well in mind the statutory purpose.
Well, they
and
do.
They say in terms that since the connection of domicile to automatic inclusion in the proceedings is maintained, because only those people who were domiciled in the United Kingdom as of the claim date will be, as a claim form date, within the opt-out class. We do not see the selection of the earlier claim form dates is in any way contrary to the rationale for the domicile date as we set out in paragraph 30.
Well, but I rely on the last sentence of paragraph 40.
Well, that's dealing with a different issue with respect. It's not dealing with this point.
Well, it says the domicile date.
It's dealing with you're entitled to say that this is all caused by Mr. Merricks' drafting of the claim form, but that's what they're talking about. What they're talking about is the claim forms should not be issued in this way. Claim form should keep separate definition of class on the one hand and domicile date on the other. They're not saying that by doing what we did, we've gone, as it were, behind or beyond the statutory purpose, because
But then why did
that's
Mr.
completely
Justice...
inconsistent with what they said in 39.
But this judgment's completely inconsistent with what was said in the remittal hearing and the judgment.
Sorry, what was said?
Well, Mr. Justice Ross said you're not suggesting the domicile date should be 1992, it's going to be 2021, isn't
Well, that's
it?
what he said in an earlier judgment. This is a fully reasoned judgment, which is what's on appeal
Well,
before us.
We
I'm
always
not
change our
really
minds.
helped by what Mr. Justice Ross may have said on a previous occasion
Well, I
when
think-
the point wasn't being argued.
Well, my lord, I think it's illuminating that the reaction was that if you're going to take your lordship's approach with respect, why not say people had a valid claim between 92 and 2008, so let's backdate it to 1992 to get the fairest class, because then you get everybody. You backdate it to 2016 because it's the claim form date, even though the party issuing the claim had no expectation that a category of people would have a claim, as they say on the face of the claim form. So it does seem to me that one is entitled to query how one got to this situation. In terms of statutory purpose, in answer to my Lord Justice Green's point, 2 points. One is, if you look at tab 4 of the authorities bundle, domicile date is defined, and it's said to mean the date specified in a collective proceedings order or collective settlement order for the purposes of determining whether a person is domiciled in the United Kingdom. Now, I appreciate that can be read in many ways, but is suggests a present tense, not was domiciled at the time that the tribunal thinks appropriate or when the claim was issued. You then look at the consultation extract at paragraph 30, and again, with respect, 5.57 seems pretty clear-cut to me. The government has therefore decided that the opt-out aspect of a claim will only apply to UK domiciled claimants. Well, that seems to me that the rationale of this is very clear, which is that people shouldn't be automatically bound by this court's proceedings and decisions unless they live here. Now, the fact that they may or may not have had a connection, so let's take an example. Say somebody in 2016 lived here on a job abroad for 6 months but their home's elsewhere. Why should a transient connection, just because the claim form happened to be issued at that time, pull them in? And that's not what the statute.
Somebody who's lived in the country during the.
So I was going to say that wouldn't necessarily make them domiciled here anyway, if they're only here for a transient
Well,
purpose.
let's say that they were here domiciled for a year.
But the only people who have a claim are those people who were here between 1992 and 2008. Now, true, it is not for the entire time necessarily, but who must have been here for long enough to make a claim.
But then
And
why
domicile.
not? But then, if that's the logic, set the date at 92 or 2008.
Well, both of those make it unworkable, because if you set it at 92, you lose the people who arrived here in 93, and then vice versa. If you set it at 2008, you're only allowed to set one date.
Well, that's right. And my lord, that is what I'm saying to the court. Using the domicile date to catch the biggest class possible on the grounds of fairness is not what it's intended for. It's simply intended to be the date for the territorial reach of this court over people who live here.
So I've got Bob the Builder going mad behind.
Sorry.
I'm sorry about this. Unfortunately, I have looked into this several times, and the arrangements between these contractors and the city corporation entitle them to make a loud noise between 12 and 2.
I'm going to elevate the
You
volume.
may have
Is that
noticed
better,
that
my
we were
lord?
blissfully quiet until about 12 o'clock, which is why one of the reasons why I wasn't over anxious to have a break, because I knew it was coming.
So, my Lord Justice Green, I'm sorry if you can hear now. I was relying on the present tense of the domicile date. I was also relying on 557 UK domiciled claimants.
I was going to reverse the proposition you just advanced to us, which is that you say your analysis holds true even if necessarily it's unfair.
I do. But I also say that your lordship is putting down the unfairness to factors I don't agree with, because in many courts, as your lordship knows, if you choose to issue a claim form 5 days before the limitation period and you have not included all the relevant parties, and then you are not allowed, pursuant to the Limitation Act 1980, to amend to add them, that's unfair, but that is the operation of the law. So that's why I'm saying to you that I don't accept the proposition that the concept of the domicile date lends itself to correcting fairness or unfairness. And the answer to your lordship's point on opt-out, opt-in is the word automatic. So the domicile date is the date at which people automatically are opted in. So there is no scope in my respectful submission for matters of policy over who should opt in or opt out to come within the concept of domicile date. It is an administrative date about extraterritoriality. It's not to expand the class or expand matters of perceived unfairness on limitation or drafting or whatever court process.
So it necessarily follows that in analysing domicile, proportionality, justice, unfairness are irrelevant. Must do. I'm putting it in an extreme form, but I think it follows.
Well, my lord.
All the matters in Rule 4, irrelevant. Even
No.
though it's an untrammelled discretion, I'm making it even more unfair for you now.
Well, my lord, the answer to that is I wouldn't ever be drawn into such an extreme position because I don't need to be. And the answer is I've given your lordship an example of where it might not be the CPO date because of a future amendment or a notification. What I would say to you is that here, I've got my target, and my target is the 5-year period, backdated way beyond any logic in my view, given the actual terms of the claim form. is that the right exercise of the tribunal's discretion? And when I've shown you the history, I know this is an unpopular point with the Chancellor, but I've shown you that you can see why we got here, and it isn't through a pure exercise of discretion of the domicile date. It is taking into account matters that we would say are irrelevant considerations here. I don't need to go as far as your lordships pressing on me. I accept that interests of justice and proportionality in Rule 4.2 have their place, but I would also say to you that if you look at that provision, it is one about managing the litigation rather than it's not about setting the jurisdictional date, that it's about managing the litigation. But of course, I'm never going to be put in a position where I say the interests of justice are completely irrelevant to every decision. But here, it's putting the cart before the horse to fix problems that the concept of domicile was not designed to do.
I think you've got that point.
Thank you, my lord. My lord, shall I just move very briefly to ground 2?
Yeah.
Well, the construction of a document is an issue of law, and I think the points made by my learned friend about this aren't right at paragraph 24 of my learned friend's skeleton, because in construing a written document, the court is always looking for the intention of the parties, but it's the objective intention of the parties. Now, can I start with, first of all, whether the court was right to look at the claim form? The answer is that it was right to look at what the class was supposed to be by definition, by reference to the claim form, but trying to ascertain a subjective intention, as the tribunal seemed to be doing, we submit was not right. It should have been objectively what was apparent in the documents. The second point is that it's trite that one looks at the document in its proper context, which would include documents served at the same time in the same suite of documents. And we identify at paragraph 58, and I've shown you this document, so at paragraph 58 of our skeleton, we identify the proposed timetable for litigation, which I've placed reliance on, the February 2017 date. And I also showed you from the tribunal's remittal judgment the notice on the website that was published about the CPO date being the time at which the date would proceed. And I also showed you in that context paragraph 23D showing that by definition, therefore, it was intended that some people who died between 2016 and 17 would not be included. So the starting point is that the tribunal's failure to look at the suite of documents and reach that conclusion on their face was an error. Now, we also say that the subsequent affirmations of the position, which I have shown your lordship, should also be have been taken into account as relevant. Now, I accept that subsequent statements and concessions are not strictly binding upon a court when looking at the true construction of a document. And if your lordships take that approach, then I will not rely on them, but I don't actually need them given what I already have at the simultaneous time. What I would say, though, is that when the tribunal...
It's a bit more than they're not strictly relevant, they're actually inadmissible, aren't they? And if what you're doing is seeking to construe a document, you can't do that by reference to subsequent...
That's right, but when
well, you can't.
When you're looking at the question... when you're looking at the question of intention, as the tribunal did, they looked at intention subjectively, and then my point on construction is separate. So on construction, absolutely I accept not relevant. No. On the question of intention, I don't need them, but I would just say that it's a bold court that says what the intention of a party was when they've got clear statements saying what it was and they ignore them. And that's what I would just say. And I would just say on the Bahamas and Threadgold case, that was also a case, picking up on a point my Lord Justice Green made, of a bilateral agreement where one party was saying what the document did or didn't mean. Here you've got a claim form which has published notices and counsel who's pleaded it saying what it means, and then the court ignores those statements and says it means something different. And we would say that's a bold one, and it probably falls more in the territory of the Kidson's case that we've cited, in which Mr. Keeley made a concession as to what an insurer had or hadn't in mind, and Lord Justice Ricks said that the concession had obviously been carefully considered and approved by his clients.
Where's that?
That's, my Lord, in the authorities bundle. Let me find you. It's tab 10, and we cite it in our skeleton. It was in my Lord's territory of a professional indemnity policy. Policy provided only for cover for claims made during the policy year or arising out of circumstances previously notified.
Yeah, I remember this case,
Yeah.
yes.
And the question was the concession made about the notification letter. And at paragraph 84,
Yeah.
Mr. Keeley, QC then, had made a concession, and Lord Justice Ricks said a judge would have to be very sure of his or her ground before rejecting such a concession. I don't need this, but I would just simply say that the tribunal's approach, as it did, of looking at the claim form in isolation, even of the documents served at the time, which made everything quite clear, was wrong. And it suggested by my learned friend that the tribunal took account of the concession, but in fact there's nothing in the judgment to suggest they did, and the permission to appeal ruling in the bundle in fact makes it clear that they didn't, because they said they were irrelevant. So, my Lord, we would say that the tribunal's approach on intention and the way it went about it was wrong. In any case, and you may say, what does that matter? But in any case, that we say the construction of the claim form, looking only at the claim form and the admissible material around it, made it plain that the intention was, in fact, to exclude at least the people who had died between the date of issue and the CPO date, which they at that stage thought was a particular date. And we say there's no other way around that. And the reliance placed by the tribunal on the class estimate was wrong, because the class estimate was incomplete. And that was absolutely clear, so they couldn't actually place reliance on that because it didn't even include anyone in 2016. So, my Lord.
It would be right, wouldn't it, that even if the tribunal were wrong to say that the objective intention of the claim form was that those persons alive at the date of issue should be included, it was nevertheless the objective intention that those persons who were alive within a reasonably short time of issue of the claim form would be included, because the reasonably short time is the time within which it was expected that the CPO would be made.
Well, can I put that slightly differently, my Lord? It was intended that those living at the domicile date would be included, and at that stage the assumption was that the domicile date would be around February 2017. But obviously, taking a point that was highly emphasised by my learned friend's predecessor below, it was always going to be open to the tribunal to set a CPO date, so that was never guaranteed that it would be 2017. And I think the point that my learned friend makes in her skeleton argument...
Contemplated it was going to be 5 years later, though, that's the point. That's exactly the point my Lord was.
I agree, but the objective intention could be broken down then into 2 points. One is that it wasn't everybody alive at the date of the claim form, and 2, that the expectation was that everybody from a certain date in 2017 would be included. But then subsequent intention, taking the point about the evolving nature of a claim form, is that it would be people from 2021. And there were clear statements as...
That's an entirely circular argument, which depends upon your being right about 2021, because if you look at it just in terms of looking at a sort of objective intention, was it objectively intended that if there was a delay as long as 5 years, everybody who died in the meantime would be excluded?
Well, my lord, all I would say to you is, I don't think there's an answer objectively on the face of the claim form to that question, because the only answer is there was an expectation of 2017. So I don't think it can be put in the way that your lordship has said as objective. And what I would say along the Kidson's case line of authority is that Miss Wakefield made a concession in 2021 on instructions. So the 2 points are separate because obviously the second isn't objective intention, but what I would say is the objective intention doesn't go as far as your lordship's saying. I think the objective intention is there's a gap between the claim form date and the CPO, the domicile date. That's plain on the face of the claim form with the documents served with it, and that it was those living at the domicile date, and I accept that the documents filed indicate that the expectation was that the domicile date would be 2017.
How does the Kidson's point arise? Because in that case, I think, if I've understood it correctly, the concession was about the meaning of a document in which the person making the concession was particularly expert.
Yeah.
Whereas here,
Got leading
the
counsel.
concession is about not the meaning of anything, but the expectation of something which the cat will do, albeit by counsel who's
Well,
expert in competition proceedings, no doubt.
leading
But
counsel.
it is slightly different.
Well, possibly worse though. Because leading counsel who's got conduct of the case with instructions, who knows all the issues about the gap that's passed and answers what the expectation of her client is as to when the CPO date is and what the date of living would be.
Lord Justice Rigg says, well, the court who's going to depart from the concession about the meaning of the document has got to be pretty sure of its ground, i.e. of its ground in deciding what the document means. What would we have to be sure of that ground about?
Your lordship put to me, was it the objective intention of the document that it would be only 2017? That was the date. And I said, I don't think that can be ascertained, because I think what you can see is the objective intention was that it wouldn't be the date of issue, but some later date.
The intention was that it would be soon after the
Well,
date of the issue of the claim form, because that's what one would expect to happen in most cases.
well, the objective intention on the face of the document, putting aside subjective intentions or common expectations, would be that it wasn't the date of issue, that it was going to be a later date, namely the date of the CPO, and that the estimate in the proposed timetable for litigation was February 17. So I was answering your lordship's question about the objective intention. You said to me, isn't it the case therefore that it had to be 2017 effectively? To which I answered, well, not really, because then there was a subsequent development and concession by leading counsel who was running the case at a time when a limitation amendment was being, or limitation was known about and an amendment was being posited. So with full appreciation of the consequences of the pleading, they'd actually put in an amendment to that very bit of the pleading. And I say that, therefore, I don't think you can say the objective intention should be held at 2017. But even if I'm wrong on that, what I can say to you categorically, and we're on ground 2, is you can't possibly find, as the tribunal did, that the objective construction of the claim form showed that it was at 2016.
Yeah, well, that's still...
And that's all I need to win on that point. And once you factor that in, you should see that there's an irrelevant consideration that has influenced the exercise of the tribunal's discretion, and it should be overturned on that reason, for that reason. unless I can assist your lordship further.
No, thank you very much, Mr. Secretary.
May it please the court. Through the debate that the court's had with Mr. Laney, I think you've really, with respect, zoned in on the key point that arises, which is precisely what is the statutory purpose of these provisions. And Mastercard needs the statutory purpose to be a very narrow and specific statutory purpose. And Ms. Delaney described the purpose as being this. She said, at the date of the CPO, which is the date that my learned friend says that the tribunal takes jurisdiction over the claim, the purpose of the provisions is that the tribunal should not assume jurisdiction over those domiciled abroad unless they specifically consent. So that's the narrow and specific statutory purpose that Mastercard need these provisions to have. Now, the reality is that there is nothing in the statute to support such a narrow purpose for the provisions. And I'm going to come to look at the statutory provisions, take you back to them in a moment. But may I just at the outset make this point? Now, if Ms. Delaney is right that the function of these provisions is to ensure that at the date of the CPO, there are no people within the class which are automatically in the proceedings unless they specifically consent, then what do we do about this? So in the present case, because of Mastercard's appeal, there has not yet been any notification of the claim because of this appeal. So the claim hasn't yet been publicised, and the opt-in and opt-out provisions have not yet been initiated. So if the CPO date is used as the domicile date, which is what Mastercard says is the only option, or was the only option for the tribunal in this case, that's the 18th of August of 2021, then 1 year and 3 months have passed already since that date. So the soonest that notification can begin is now 1 year and 3 months later. And of course there will, in that interim period, on my learned friend's argument, be people that have moved out of the jurisdiction that are nonetheless bound in because the CPO date was set 1 year and 3 months earlier. But Mastercard's not saying, well, actually the CPO date shouldn't be the domicile date. The domicile date should be the date of publication, notification of the claim, and the date in which these opt-in and opt-out provisions are initiated. They're not saying that. And it seems to me that as soon as they're not saying that, then their statutory construction argument really collapses. Because the reality of the matter is, and I'm going to come to look at the statutory provisions, the reality of the matter is this, that of course, as the tribunal recognised, the purpose of having a domicile date is to determine who opts in and who opts out. So that's the purpose of it. But there is nothing in the statute that says that the date needs to be fixed at the CPO date. Now, undoubtedly, there'll be lots of cases in which that's appropriate, and we've seen the table that's been produced by Mastercard. But there'll be other cases, and this is one, in which it's not appropriate. And in all cases, there may be arguments going either way. It's a question of degree. Now, looking at, perhaps we could turn to the legislation itself. So, if we pick up the authorities, please, behind tab 3. Tab 3. Sorry, tab 2. And we've got section 47B there. Now, I know that the court has this point, but in passing, I'm just going to reinforce the point that Mastercard, it's inaccurate for Mastercard to say the tribunal is asserting jurisdiction when it grants the CPO, because we see that the structure of the legislation is not consistent with that submission. So we can see from section 47B1 that proceedings may be brought before the tribunal combining two or more claims to which section 47A applies. So the claims are brought. And indeed we see from subsection 3B that the proceedings may indeed combine claims which have been made already under section 47A and over which the tribunal undoubtedly has jurisdiction already. And then we see at 4, subsection 4, that collective proceedings may be continued only if the tribunal makes a collective proceedings order. And so the submission that my learned friend made repeatedly about the CPO date being the date on which the tribunal asserts jurisdiction over the class is simply incorrect. But that really is a keystone to her submissions, because she needs it to be the CPO date, which is the date, that is her submission, that the narrow purpose of these provisions requires that when the tribunal asserts jurisdiction over foreign domiciliaries, they should be able to, at that stage, specifically opt in. And that submission hinges on the date of jurisdiction being the date of the CPO. And we say that the first point that we make is that that's...
Jurisdiction is founded on the issue of the proceedings.
That's right, my lord, that's what we say.
In competition cases like in every other case.
That's correct. And that's really...
And that, I mean, that's absolutely plain, isn't it, from 47B, 3, B and C.
Yes, exactly.
And C talks about may continue proceedings which have already been commenced under 47A.
That's right.
By definition, the cat's already got jurisdiction over there.
My lord, precisely so.
Yeah, okay.
Then we see at section 47B 7C, so that's just over the page. So looking at so 7, subsection 7 says a collective proceedings order must include the following matters. And if we go to the top of the following page and look at subsection C, that's specification of the proceedings as opt-in or opt-out collective proceedings. See subsections 10 and 11. And then we see at subsection 11, so subsection 10 defines, as you've seen, opt-in collective proceedings, which we're not concerned with. Subsection 11 defines opt-out collective proceedings as being proceedings which are brought on behalf of each class member, except for any class member who opts out by notifying the representative in a manner and by a time specified. And B, any class member who's not domiciled in the United Kingdom and at a time specified and does not in a manner and by a time specified opt in by notifying the representative that the claim should be included in the collective proceedings. And so what we see there is we emphasise the words at a time specified. And you see at subsection 14, in this section, specified means specified in a direction made by the tribunal. So what Parliament has decided is that the domicile date shouldn't be fixed at a particular date in the proceedings, but should be left to the discretion of the tribunal. Is it a date specified, and that is at the direction, in a direction by the tribunal.
If we just go back, if we may, briefly to the question when jurisdiction is founded or
Yes.
asserted. I mean, the typical rule concerned with issue of proceedings relates to when jurisdiction is founded against a defendant. We're not concerned with that. We're concerned with whether it is founded against someone who is named in the class, but who has given no authority to the representative to represent him. Now, why should the representative who hasn't got a collective proceedings order and may never get one, be able to say the jurisdiction is founded over all these people specified in the class? It does seem to me to be a different question, even if the answer to it may be the same.
My Lord, I think that my Lord raises a good point, and I think that jurisdiction is being used in different senses in my learned friend's argument as well. And so, for example, in her argument, she relies on paragraph 30 of the tribunal's judgment and the consultation document, and the idea that the court, the tribunal, shouldn't be asserting jurisdiction over lots of foreign parties, what my learned friend calls the extraterritoriality point. But my Lord is right that that issue that's not jurisdiction in the sense that we normally understand it. So the court, by definition, has jurisdiction over these claims because, for example, the defendant is domiciled here or whatever the basis is for jurisdiction. So these are claims which, in principle, the court has jurisdiction over. So there's not a question wherever you draw the line. There's no question of the tribunal asserting the jurisdiction of the court or of the tribunal over persons that shouldn't have it, because the claim is one which the court has jurisdiction to hear. If not, there would be a jurisdictional challenge. So I think that's an important point to draw out. I think that my Lord's asking makes a related point, which is why that true it might be that the tribunal has jurisdiction in principle over these claimants, but if they haven't specifically opted in and they're domiciled abroad, why should the claim be continued against them? And I do think that is undoubtedly a consideration that the tribunal in its discretion will take into account. And as the tribunal correctly said, the rationale for having a domicile date is indeed to ensure a connection between class members, represented persons, and the jurisdiction. So that's undoubtedly why it's there. But the real question for the court is, does that mean that the statutory purpose is so narrow as to require the tribunal to set at the CPO date, set the domicile date at the CPO date on the basis that what the statute is doing is requiring the tribunal to set the domicile date then, so as to avoid any foreign domiciliary from being bound up by the proceedings when they haven't consented. I think that's the point that my learned friend has to persuade you of. And we say that there's simply no basis for that in the legislation, because if Parliament had intended that, then Parliament could very easily have said or have provided in the legislation that the domicile date should be the date of the Collective Proceedings Order, because at that point, then that's the best way of achieving the narrow objective that Mastercard is attempting to persuade the court of. But it hasn't done that.
I understand that. And that's perhaps a slightly different point. I was just probing the question of when jurisdiction is founded or asserted against people named in the class who have given no authority to the representative, as distinct from when jurisdiction is established against defendants. But anyway, I take your point about the purpose of the...
And the statute is really dealing with a different point, isn't it? Because the statute's dealing with the bringing of proceedings. It talks about proceedings being brought.
Yes.
And then you can only continue the proceedings in certain circumstances. Not actually addressing jurisdiction as such.
No.
At all.
No, my lord, and that's right. And so I think that when the claim is brought on behalf of all of the class members that fall within the class, the tribunal, in the normal way that we understand the word jurisdiction, has jurisdiction over those claims because the claim has been issued. But then because it's collective proceedings, there's then a subsequent step, which is the opt-in or opt-out step. So there's jurisdiction over the class. And then what happens at the subsequent stage is not really a question of jurisdiction at all, but of particular class members either opting in or opting out. So it's not really jurisdiction in the sense that the word's generally used. Jurisdiction in the sense that we understand the term happens at the outset when the claim is filed. There's jurisdiction at the class, over the class at that stage.
So it's really certification. It's certification of a claim as legitimately representing a potentially vast number of people who know nothing about the litigation.
Yes.
Once certified, you in a sense backdate it to the date of the claim. You've certified it. But you're right, the tribunal has jurisdiction from the claim to the point of certification when it makes the CPO. then it goes on or doesn't go on, as the case may be.
That's right. And so that's why I say for my learned friend to say that the tribunal's asserting jurisdiction at the CPO stage is wrong. It's not asserting jurisdiction. It's certifying the claim. It's permitting the claim to be continued. And of course, even if one's looking at it in terms of it can't be right that they're asserting jurisdiction over persons at the date of the CPO, because it's after the CPO is made and the claim is notified that persons opt in and opt out. So
And actually, it's interesting, if one goes to paragraph 30 of the judgment and paragraph 556 of the government responsible consultation, the opening words, the government recognises business would rightly have concerns if a claim could be brought against them in UK courts on behalf of anyone in the world. that is tying in on the bringing of the claim.
yes,
It's being made by foreign domiciliaries, which
Yes.
suggests that, well, it suggests at least that this analysis isn't really concerned with saying, well, you shouldn't be able to bring a claim if at the date of the CPO somebody is abroad.
no, we would agree with that. So we say that the purpose of the statutory provision is to provide for a domicile date, and the purpose of the domicile date is to ensure appropriately in each case a degree of connection with the United Kingdom, with the jurisdiction. But what it's not doing is specifying that the domicile date should be at the date of the CPO, and it's also not saying that the tribunal must, when setting the domicile date, ensure that that nobody who's resident at the point of the CPO outside the jurisdiction, which is how my learned friend put it, is bound by the proceedings unless they specifically opt in.
Well, what you've just said is actually what the tribunal itself said in paragraph 30.
Yes,
Not considered appropriate automatically to include people who lacked a close connection with the UK.
yes, and also
The domicile date is intending to ensure that there is a connection with the United Kingdom.
that's right, and it's
But
also
it
what
doesn't tell you anything
Sorry.
about when the domicile date should be, because by definition, when whatever the date is, the people in the class will have a connection.
My lord, exactly right. And they also make the point clearly at paragraph 39, where they say, which is, I think, a point that you put to my learned friend, which is the connection of domicile to automatic inclusion is maintained. So that's what it's all about. It's maintaining this connection between domicile and automatic inclusion, but it's not specifying when that should happen.
So you would say then that it would be consistent or not inconsistent with the statutory purpose and the avoidance of problems about infringement of sovereignty for, as it were, the default rule for the CAT to be the date of issue of a claim.
Well, I don't have to go that far, my lord, because
I think that's the logic of what you've just been submitting.
well, with respect, I don't know, because we don't say that there is a default rule. So our position is that there is no default rule and that it's a matter for the tribunal's discretion. And we can quite see that in many cases, it may well be appropriate, and this is what the tribunal's done in practice, as my learned friend said, it may well be appropriate to set the domicile date at the date of the CPO, because there may not be other countervailing factors. In most cases, because of the warning, especially given by the tribunal at paragraph 40, about not defining the class by reference to the domicile date, this simply won't arise. And so it may be that in the vast majority of cases, the CPO date is the appropriate date. We don't shy away from that.
As my lord and I know from having dealt with a few of these collective proceedings orders cases, the issue about foreign domicile is probably more apparent than real in a number of these cases. And the Patarel case, from recollection, was concerned with elderly people.
People who had accounts
Who
with
had
BT
accounts
in
with
this country.
BT and didn't have they hadn't had a bundle or whatever it was called, and they were still using landlines and being charged a lot of money. Well, those people by definition are people who are unlikely to, they may have moved abroad, but at the relevant time they'd have been domiciled in the United Kingdom.
My lord, precisely so, and we say in the circumstances of this case, when you're looking so far back between 1992 and 2008, we say that for that reason, so by definition, you had to have been resident here at some point at least, all that time ago. And so the idea that vast numbers of people are going to be resident here still in 2016 but have moved by 2021 of that class, we say is wrong. And the tribunal found that we see that in the last sentence of paragraph 34. They say, we think it's obvious that for the great majority of those who were resident in the UK for all or part of the infringement period, their domicile will not have changed between 2016 and 2021. But my lord, just going back to the point I opened with, just to explore this a little further. So it's one. I see it's past 1 o'clock. Shall I?
I was going to say, can we do
I'll
that?
hold that thought.
We'll do that at 2:05, please.
Yes, of course.
So if I pause 2. Thank you.
All rise.